take a leave of absence. Take a leave of absence. Take a leave of absence.
Immediately at issue, Jonathan, is when the relationship between Fani Willis and Nathan Wade began. They insist that it didn't start until after Wade was hired in 2022, but Wade's former divorce lawyer, who's also a colleague at his law firm, his name is Terrence Bradley, claims that the relationship began way back in 2021 before Fani Willis even became the Attorney General. That's a huge discrepancy.
It is, and this universe just gets stranger and stranger. Usually a former counsel, let alone a former partner, doesn't come forth with evidence suggesting that you have lied. But what makes this very serious is that these alleged false statements were put into an affidavit, and that affidavit was filed with other papers with the court. Keep in mind, Wade and Willis are prosecuting defendants in this case for making false statements and filing false papers or material with the court. So they are prosecuting people for exactly this type of allegation. Now, that's not the type of experience you're looking for in prosecutors. It's the type of thing that raises conflicts of interest. But if it is shown, and it's being suggested there are witnesses to this fact, that their relationship preceded the hiring of Nathan Wade, they're in serious difficulty. I mean, they are being accused of filing false statements with a court.
You wrote a lengthy column on this on your website, and you included a link to the affidavit that Nathan Wade filed with the court, which includes in part the statement, quote, "In 2022, District Attorney Willis and I developed a personal relationship in addition to our professional association and friendship." Again there, in 2022. But Ashley Merchant, who is the attorney for Michael Roman, who brought the challenge against Fani Willis, says since Willis and Wade were not forthright about their relationship in the first instance, there is no reason to believe that they are telling the truth now. If indeed they did not tell the truth in this sworn affidavit to the court, what are the implications?
Well, their position in this case has become untenable if this is proven to be true. Indeed, both of these attorneys could be looking at serious repercussions for filing a false statement of this kind. This was not some aside. This was the core of their argument. This is what they were flagging in the papers and raising with the court, that because the relationship started in 2022, there is less of a conflict of interest or other ethical problems associated with their relationship. If they misrepresented that date, then not only is their position as prosecutors in the case thrown into question, but their position as counsel, as attorneys, is thrown into question with courts. They could be referred to the bar for other possible action.
And the judge in this case in Georgia said that these allegations against District Attorney Willis could result in Willis being disqualified from the case. And as such, he said he definitely wants to hear evidence on these allegations on Thursday of this week. So it all makes for a very, very busy week in terms of the legal part of our political news now. But it also puts District Attorney Fani Willis in quite a spot. I mean, regardless of what you or anybody else might think about Willis's personal relationship with this prosecutor and whether she did anything legally wrong here, the only person whose opinion really matters on that right now is the judge. And today in court, he did make clear, he did say explicitly that he thinks she might be disqualified from this case because of these allegations. Now, the key dynamic at work around this is that if Fani Willis is disqualified, fairly or unfairly, her whole office, the whole district attorney's office, is disqualified from working on that case, which would mean, in all likelihood, that whole case would go away. And that is why Georgia State University law professor Clark Cunningham argued in the New York Times last month that the best thing Fani Willis could do to protect her case against Trump and his RICO defendants in Georgia would be for her to take a leave of absence, for her to take a personal leave of absence from the district attorney's office to turn over the case to a deputy district attorney. That would end these proceedings against her effectively, and it would leave her office in charge of the case, and the case could still go forward. We contacted Professor Cunningham about this today, these new developments. He told us, quote, This action, meaning a personal leave by District Attorney Willis, should be looked at strategically as the best option she has to make this enormously distracting controversy go away and to put the case back on track, still in the control of the Fulton County DA's office. If Judge McAfee grants any of the motions to disqualify Willis at the hearing Thursday this week, then her option to take leave probably disappears at that point. Take a leave of absence. Take a leave of absence. Take a leave of absence.